A lot of times it's going to depend on the lease, right, and what is set to be right or wrong between the parties. So if the tenant is materially breaching that lease, you have to give them notice. Now there's going to be a statutory notice, and it also potentially is in the lease, right? So you got to make sure that your notice under the statutes and your notice under the lease coincide, right? So if the statutes say 15 days, but your lease says 30 days, you have to abide by the terms of your lease. So the first thing to do is put the tenant on appropriate notice of their alleged breach or default in the lease. Second is going to be typically, to work it out with the tenant. It's not in either party's best interest to evict if you can avoid it. It costs money, it puts a judgment on the tenant. Sometimes it's a good tenant who's just having a hard time. The next step would be to actually file the complaint in the county for eviction, then work through the eviction process.